Hello learners, I am Krishna Kumar, Faculty of Law at School of Law, Dr. Hari Singh Gaur Vishwavidyalaya, Sagar, Madhya Pradesh. Today's topic of our discussion and learning is all about the Prevention of Food Adulteration Act 1954. But before I move ahead to the introduction of this discussion, let me introduce you about what we are going to learn today. Today's lecture is divided into following modules. Module 1, Introduction. Module 2, Definition. Module 3, Contents and Structure of the Act, Part A. Module 4, Contents and Structure of the Act, Part B. Module 5, The Prevention of Food Adulteration Rules 1955. Module 6, Conclusion. As we all know that not only today, but from the time immemorial, since the start of life on earth, food is one of the basic necessities for the sustenance of not only human life, but for every being. For human beings, pure, fresh and healthy diet is most essential for the health. It is no wonder to say that health of citizens is national wealth. Adulteration of foodstuffs was so rampant, widespread and persistent that nothing short of somewhat drastic remedy in the form of comprehensive legislation became the need of the hour. Adulteration of foodstuffs and other goods is now included in the concurrent list in the Constitution of India. Due to the lack of uniformity in the state legislations passed at different times without mutual consultation, the Centre enacted the Prevention of Food Adulteration Act 1954. The Prevention of Food Adulteration Act 1954 deals with the eradication of the evil of food adulteration, prohibition of the adulteration and misbranding of foodstuff, regulation of consumer supply relations and prescribing punishments for the adulterators, because there existed an acute need to curtail this antisocial and economic evil, which was widespread and rampant in the society. This act attempts to ensure that the food is prepared, packed and stored under sanitary conditions and accordingly made available to the people. It came into effect from 1st June 1955 and extends to the whole of India. Its main intention is to curb this evil at its root level itself, that is, to curb the food adulteration activities of the small vendors or retailers in the society. The compliances under this act are strict in nature and any non-compliance results into prosecution. Now we will discuss some of the important terms used and defined in the act. Meaning of adulteration. Adulteration means the act or the process of adultering, the state of being adulterated, that is, it implies making impure by adding or mixing anything inferior or spurious. According to the section 2I of the act, any material which is or could be employed for the purpose of adulteration is called adulterant. According to section 2IA of the act, an article of food shall be deemed to be adulterated if it contains any other substance which affects or is so processed as to affect injuriously the nature, substance and quality thereof. Or B, any inferior or cheaper substance has been substituted wholly or in part of the article so as to affect injuriously the nature, substance or quality thereof. Or C, any constituent of the article has been wholly or in part abstracted so as to affect injuriously the nature, substances or quality thereof, defines adulterated, as if an article of food is not of the quality demanded by the purchaser, and if not of the quality which it purports or represents, it can be said to be adulterated. Or D, the article had been prepared, packed or kept under insanitary conditions whereby it becomes contaminated and injurious to health. Or E, the article consists wholly or in part any filthy, putrid rotten, decomposed or deceased animal of vegetable substance, or is insect infested or is otherwise unfit for human consumption. Or F, the article is obtained from a diseased animal. Or 7th, the article contains any poisonous or other ingredients which renders it injurious to health. Or G, the container of the article is composed, whether wholly or in part, of any poisonous or deleterious substance which renders its contents injurious to health. Or H, any coloring matter than that prescribed in respect thereof is present in the article, or if the amounts of the prescribed coloring matter which is present in the article are not within the prescribed limits of the variability. Or I, the article contains any prohibited preservative or permitted preservative in excess of the prescribed limits. Or J, the quality or purity of the article falls below standard, or its constituents are present in quantities not within the prescribed limits of variability, but which renders it injurious to health. Or K, the quality of purity of article falls below the prescribed standard, or its constituents are present in quantities not within the prescribed limits of variability, but which does not render it injurious to health, etc. An article is not deemed to be adulterated where the quality or purity of the article has fallen below the prescribed standards, or its constituents are present in the quantities not within the prescribed limits of variability, solely due to the natural causes and beyond the control of human agency. Also, where two or more articles of primary food are mixed together and the resultant article of food is stored, sold or distributed under a name which denotes the ingredients thereof and is not injurious to health, such an article is not deemed to be adulterated. In a case, the food inspector purchased some chili powder from the appellant for analysis in accordance with the Act to check adulteration and sent its sample for analysis. According to the public analyst, ash was found mixed with the sample obtained from the appellant, and its concentration was 8.38% by weight. However, there could be a possibility of some error in the analysis. In this case, the appellant was convicted by the lower court, but the apex court held that the adulteration found in the sample was marginal, and there being possibility of error in analysis also, it would be unsafe to uphold the conviction of the appellant. While in other case, a mere addition of salt to a chili powder has been held to make it injurious to health, and it was considered adulterated on the ground that the quantity and the purity of the article below the prescribed standard. According to section 2(5) of the Act, the term food has been given a very wide meaning. It means any article used as food or drink for human consumption other than the drugs and water, and includes a. any article which ordinarily enters into or is used in the composition or preparation of human food, b. any flavoring matter or condiments, c. any other article which the central government may, having regard to its use, nature, substance or quality, declare by notification in the official gazette as food for the purposes of the Act. The Act also deals with the misbranded food items. Under section 2(9), an article of food can be declared as misbranded if a. it is an imitation of or is a substitute for or resembles in any manner likely to deceive another article of food under the name of which it is sold, and is not plainly and conspicuously labeled so as to indicate its true character, or b. it is falsely stated to be the product of any place or country, or c. it is sold by a name which belongs to another article of food, or D, it is so colored, flavored or coated, powdered or polished that the fact that the article is damaged is concealed, or if the article is made to appear better or of greater value than it really is, or E, false claims are made for it upon the label or otherwise, or F, it is sold in packages which have been sealed or prepared by or at the instance of the manufacturer or producer and which bear his names and address. The contents of each package are not conspicuously and correctly stated on the outside thereof within the limits of variability prescribed under the Act, or G, the package containing it or the label on the package bears any statement, design or device regarding the ingredients or the substances contained therein which is false or misleading in any material particular, or the package is otherwise deceptive with respect to its contents, or H, the package containing it or the label on the package bears the name of a fictitious individual or company as the manufacturer or producer of the article, or I, it purports to be or is represented as being for special dietary uses unless its labels bear such information as may be prescribed concerning its vitamin, mineral or other dietary properties in order to sufficiently to inform its purchaser as to its value for such uses, or J, it contains any artificial flavoring, artificial coloring or chemical preservative without a declaratory label stating that fact or in contravention of the requirements of this Act, or rules made thereunder, or K, it is not labelled in the accordance with the requirements of the Act or rules made thereunder. Any article of food being a produce of agriculture or horticulture in its natural form means primary food under section 212A. For the purpose of determining the liability under the Act, the term sale under section 213 has been defined to mean the sale of any article of food whether for cash or on credit or by way of exchange and whether by wholesale or retail, for human consumption or use or for analysis, and includes any agreement for sale, an offer for sale, the exposing for sale or having in possession for sale of any such article, and includes also an attempt to sell any such article. Now, we will discuss the content and structure of the Act, which is divided into two parts, that is module 3rd and module 4th. Under this module, we will discuss the initial half of the Act. This social economic legislation of 1954 is an act to make provision for the prevention of food adulteration. The whole Act is comprising of 23 sections. The Act comprises of provisions regarding preliminary, Central Committee for Food Standards and Central Food Laboratory, general provisions as to food, analysis of food and miscellaneous. The Act further provides for the constitution of a Central Committee for Food Standards and also vests central government with powers regarding setting up of standards of quality for the articles of food and other related matters. The preliminary part comprises of short title and commencement, definitions and the rule of construction. The Act also provides for the constitution of Central Committee for Food Standards and Central Food Laboratory. Both are constituted by the central government through notification in the official gazette to carry on the activities assigned to it. Under section 3 of the Act, the central government is empowered to constitute a committee called the Central Committee for Food Standards to advise the center and the state governments on matters arising out of the administration of this Act and to carry out the other related functions. The committee shall consist of the A. Director General, Health Services, ex officio member and chairman. B. The director or the directors of Central Food Laboratory or laboratories. C. 2 experts nominated. D. 1 representative each of the departments of food and agriculture, the Central Ministry of Food and Agriculture, Commerce, Defence, Industry, Supply and Railways nominated. E. 1 representative each nominated by the government of each state. F. 2 representatives nominated representing the union territories. 1 representative each nominated to represent the agricultural, commercial and industrial interests. H. 5 representatives nominated to represent the consumers' interests, one of whom to be from the hotel industry. All the above nominations are to be made by the central government. I. 1 representative of the medical profession nominated by the Indian Council of Medical Research. J. 1 representative nominated by the Indian Standards Institution referred to in clause E of section 2 of the Indian Standards Institution Certification Marks Act 1952. The rules to prescribe the functions of a central food laboratory and the local area or areas within which such a laboratory may carry out its functions are to be framed by the central government in consultation with the Central Committee for Food Standards. The procedure for the submission of samples of articles of food for analysis or tests to laboratory are also to be prescribed by the central government in the like manner under section 4 of the Act. The general provisions of food contains the legal provisions pertaining to food like prohibition of import of certain food articles into India or prohibition of manufacture, sale, etc. of certain articles of food like adulterated food, misbranded food, etc. under section 5 of the Act, while section 6 of the Act provides for the detention of prohibited article of food. Section 7 of the Act prohibits manufacture of sale, store or distribution of any adulterated food and misbranded food also. In fact, it lists out and gives a clear description of the prohibited items. For analysis of quality of food, the central government or the state government under section 8 of the Act by notification in the official gazette are empowered to appoint public analysts or the food inspectors processing and prescribing qualifications for such local areas as prescribed. Under section 9 of the Act, a food inspector can be appointed by the central or state government. The food inspectors are deemed to be a public servant within the section 21 of IPC. The food inspector under section 10 is empowered to take samples and send it for analysis to public analyst. The food inspector is also empowered to exercise the authority of a police officer under section 42 of CRPC for the purpose of ascertaining the true name and residence of the person from whom a sample is taken or an article of food is seized. Procedure to be followed by food inspectors. Under section 11, the food inspector will have to send one part of the sample to the public analyst and the 2 parts to the local health authority. The public analyst on his completion of the said analysis submit a report in the prescribed form to the local health authority, and if the food analyzed is adulterated, he may institute the proceedings against the concerned persons in the prescribed manner and inform them that they may make an application to the court within a period of 10 days from the date of receipt of the copy of such report to get the sample of such food analyzed by the Central Food Laboratory, whose certificate is final and binding. Section 12 of the Act also empowers the purchaser or a recognized consumer association to analyze an article of food by the public analyst on the payment of prescribed fee, which is to be refunded if the report shows that the food is adulterated. Under this module, we will discuss the later half of the Act. The Act also contains certain miscellaneous provisions like the manufacturers, distributors and dealers to give warranty in the prescribed form to the vendor prior to their sale of food articles to them under section 14, while under section 14A he shall disclose the name etc. of the person from whom such article is purchased to the food inspector if needed. Section 15 deals with the involvement of medical practitioners to inform the occurrence of food poisoning within their acknowledgement to the prescribed officer as in the notification. Section 16 provides for the penalties for contravention of the provisions of this Act regarding the import into India or manufacture or distribute any adulterated or misbranded article of food is punished with an imprisonment extending 6 months to 3 years and fine not less than rupees 1000. The punishments for other offences relating to food adulteration are also prescribed under the section. Section 17 of the Act mentions the offences committed by the companies. For the offences committed by the companies, the person in charge has been made liable who may be excused on proving that the offence committed was without his knowledge and he exercised due diligence to prevent the commission of the offence. Otherwise, he or she may be punished with the same penalty as is prescribed under section 16 of the Act. Section 18 provides for the forfeiture of the article of food by the government which is found to be in the contravention of the provisions of the Act. The Act under section 19 also prescribes the defences available during the prosecution of the vendor etc. The prosecution for offences under this Act other than those relating to warranty can be instituted only by or with the written consent of the central or state governments or a person authorized in this behalf by either of them. However, a prosecution for an offence under this Act may also be instituted by a purchaser or recognized consumer association on the production of a copy of the report of the public analyst along with the complaint in the court. The Act requires that any court inferior to that of the metropolitan magistrate or a judicial magistrate of the first class cannot try an offence under the Act. Further, the Act also empowers the appropriate governments to make rules in consonance of which the Prevention of Food Adulteration Rules 1955 have been framed by the central government. Section 24 empowers the state governments to make rules with regard to the implementation of the provisions of the Act. The Prevention of Food Adulteration Rules 1955 are the rules applicable to the whole of India, which are divided from Part 1 to Part 19 with 3 appendix A, B and C, wherein it deals with the different aspects pertaining to the following: prevention of food adulteration like its applicability to the whole of India, functions and analysis of food samples by the Central Food Laboratory, the quality standards and its definitions, the qualifications, appointments, duties, powers and the working style of the public analysts and food inspectors, the procedure pertaining to the sealing, fastening and dispatch of samples, extent of coloring, packaging and labeling of the food articles, prohibition, regulation and conditions of sales, procedure for obtaining the license for sale of food articles, provisions pertaining to the usage of different food articles like preservatives, poisonous metals, crop contaminants and naturally occurring toxic substances or antioxidants, emulsifying, stabilizing agents, etc. adulteration of food remains one of the serious problems in India due to scarcity of conditions, poor purchasing power of the vast majority of population and ignorance of the consumers. It has been difficult for the state to effectively supervise trading activities of public and private undertakings engaged in production, distribution and sale of foodstuffs. The primary objective of the law is to protect the health of the community and to prevent the supply of adulterated foodstuffs by any person as a part of his business activity. The Act is, however, highly technical and complex. It is very difficult to assume that the law has fully succeeded in attaining its objectives. The rules framed under the Act deals with diverse matters of fixing standards of quality of numerous articles of food, collection of samples, use of preservatives and flavoring agents, licensing and labeling of food, etc. There is a need to fix accountability in case of negligence on the part of inspectors or any other officers in the implementation of relevant directions under the Act. People should be encouraged to make complaints against the adulterers without fear. There is also lack of enough manpower, inspectors, lack of infrastructure, labs and no time frame for tests also. It is a very weak law and the punishment part of it is also defective because of too small fines. So, the system needs to be overhauled at its earliest. The Indian government enacted a new food law known as the Food Safety and Standards Act 2006, and to give effect to the provisions of this Act, rules and regulations have been made thereunder known as Food Safety and Standards Rules 2011 and Regulations 2011. The Act, rules and regulations have come into force with effect from 5th of August 2011. The Food Safety Act consolidates all the previously existing laws relating to the food, and to establish the Food Safety and Standards Authority of India for laying down science based standards for articles of food, and to regulate their manufacture, storage, distribution, sale and import to ensure availability of safe and wholesome food for human consumption. The Food Authority acts as a single window to provide guidance and issue clarifications, advisories for all matters relating to food safety. It is a correction into all food laws prevailing in India. So, students, hope in this lecture you have got a detailed idea about the Prevention of Food Adulteration Act 1954. If you have missed any of the lecture in this series or modules, you may log on to our website www.cec.nic.in for LOR, frequently asked questions, assignments and many more. I will again meet you in another session with more learning lectures in coming episodes. So, till then, keep learning. Thank you.